All right, I think we're ready to get started. Good afternoon or good morning, everybody, depending on where you are. Thanks for joining. My name is Joe DiLorenzo. I'm the Associate Administrator for Transit Safety and Oversight and Chief Safety Officer at FTA. We appreciate you all joining us today for this webinar on whistleblower protection for transit workers. Just a quick note that we will be recording this webinar, so please search out the link if you need it after for other folks in your organization or other people that you think may be interested or need to hear the information that we have available, and we'd appreciate that, and we'll share it as much as we can. So appreciate that, and thanks again for joining. We have well over 100 people on today, and people still coming in regularly, so really happy to see that. And just to get started, we're going to do a couple of quick poll questions just to get a feel for what's happening out there. So I guess we can go ahead and pull up the poll question. The first one being where folks are located from. So if you go ahead and enter your information in there. Tell us a little bit about what type of job role you're taking on and what you hope to learn from today's webinar or the questions that we have for you. All right, so can we see what the results look like for those? All right, well, I cannot, so I think we'll probably go ahead and move on, and I'll get things rolling, and maybe we can. Oh, there we go. So it looks like can't really see, the information about where folks are located from, but it looks like we have a good variety of folks that are here from a variety of different roles. So that's really good because, as I said earlier, we really want to make sure that we kind of get the word out on this particular topic throughout the organizations. So again, appreciate you all, everybody joining us, and hopefully we'll be able to get through and answer all of your questions and provide you some good, valuable information. So with that, I'll go ahead and just tell you a little bit about what's to come. Today we have our very excited to have our partners from the Occupational Safety and Health Administration, who are going to be our presenters today, focusing on OSHA's Whistleblower Protection Program. The Whistleblower Protection Program enforces all of the laws that protect transit employees from retaliation from reporting certain safety and security incidents. And I think, as everybody knows, we've talked a fair amount at FTA about enforcing and having good communication throughout organizations on safety, and that really being a cornerstone for having a good safety culture and improving safety in all of our organizations. So OSHA is going to present on the protections that are afforded to frontline transit workers under the existing laws, and the Whistleblower Protection Program processes and procedures for frontline transit workers to report incidents. So I'm going to introduce our speakers in a second, but just a little bit about how FTA and OSHA fit together and work together on these issues. As you may know, FTA administers the National Transit Safety Program and compliance oversight process to advance the safe, reliable, and equitable transit service throughout the United States. In our office here at Transit Safety and Oversight, that's our main goal, is to focus on safety issues, and really keeping transit workers safe is one of our primary priorities and been a large focus of FTA's since the passing of the bipartisan infrastructure law. We're really happy to be partnering with organizations like OSHA that have a shared mission in protecting workers and enhancing worker safety. In August of 2007, the National Transit System Security Act was enacted, which established retaliation protections for public transportation workers. OSHA and FTA have complementary responsibilities for protecting the safety and health of public transportation employees and the public. As the main federal point of contact of the transit industry, if transit workers come to us at FTA inquiring about how to file a complaint, we work to ensure that they are provided with all of the appropriate contact information for OSHA and advise them on the timeline and other procedural issues they need to know. FTA's collaboration with OSHA on whistleblower protections is critical to ensure that transit workers are free from retaliation when reporting alleged violations of any federal law, rule, or regulation relating to public transportation safety security. I think it's really important to remember how critical these protections are, and as I said earlier, how critical that type of communication is to improving safety throughout the industry. So with that, I'm going to introduce our speakers. First is Megan Smith, who's a program analyst in the policy division of OSHA's Directorate of Whistleblower Protection Programs. Her main duties include training and outreach, and she's the primary liaison between the Directorate and FTA. Also, we have Jared Klein, who's OSHA's Region 9 Whistleblower Retaliation Investigator located in San Francisco, California. He's assigned to investigate complaints for the entire Western United States and Guam. Jared has been with OSHA since 2016 and is currently on a detailed assignment to the Directorate of Whistleblower Protection Programs. Following both Megan and Jared's presentations, there'll be time for some Q&A. So if you'd like to ask a question, please drop it in the Q&A box. We also got some questions through registration that we'll try and address throughout their presentations, and if not, we'll cover it at the end. So with that, I'll go ahead and turn it over to Megan. Thanks again for joining.
All right, thank you. Hopefully everybody can hear me. I've been having some interesting technological issues today. I'm in the office today, and it's always a little bit interesting when you move from place to place. Thanks again. As you said, my name is Megan Smith, and I'm a program analyst in OSHA's Directorate of Whistleblower Protection Programs. I'm going to start off the presentation, and then my colleague Jared Klein is going to take over for the second half. Next slide, please. Today, we're going to cover 4 main topics. We're going to give you information on OSHA's whistleblower program. We're going to discuss some coverage issues, identify pertinent statutory and regulatory provisions that are going to apply to transit workers, and Jared is going to explain OSHA's whistleblower investigation process. And because we did receive questions before the presentation, I tried to incorporate answers to as many of them as possible throughout. Next slide, please. So before I talk about OSHA's whistleblower program, I want to explain that OSHA has sort of 2 components. We have both safety enforcement and whistleblower enforcement. And safety complaints and whistleblower complaints are investigated differently and have different rules. For example, an employee can file a safety complaint anonymously, but whistleblower complaints cannot be filed anonymously. And if you have a safety complaint not relating to operating a vehicle, for example, there's an unsafe condition in the building in which you work, you can file a safety complaint with OSHA. And more information about filing those complaints can be found at OSHA.gov. And so that's the most I'm going to be talking about safety complaints today. And so now we're going to transfer to talking about our program, the whistleblower program. So federal OSHA is responsible for protecting workers from retaliation under a total of 25 different statutes. Some cover worker safety and health, such as Section 11C of the Occupational Safety and Health Act, and which we typically refer to as Section 11C. We have 7 different statutes covering transportation services, including airlines, railroads, the trucking industry, pipelines, intermodal cargo containers, ships, and importantly for this presentation, public transit systems. We also cover statutes involving fraud and financial services, including banking and the financial industry. We have 6 statutes covering environmental protections, 1 statute covering nuclear protections, consumer safety protections, including food safety, consumer product safety, and defects in construction of motor vehicles. And we even have a statute that protects certain reported violations under Title I of the Affordable Care Act. Congress, in its infinite wisdom, has given us 3 new statutes since 2019. So our program, what we cover keeps getting bigger and bigger. So, and we've recently been getting statutes away from the safety side. So those covering taxpayers, antitrust, and money laundering. This is also a point where I'd like to stop and say that just a quick note that we received a couple of questions about training before the webinar. and what kind of training is required about whistleblower issues. And while various statutes may require safety training for employees, there's no specific requirement that employees be trained on their whistleblower rights, even though it's a good practice and it's something we recommend. In addition, we also had someone ask about how to promote safety reporting. And I'd like to point out that we have a document on our website, www.whistleblowers.gov. And I'll refer to that website a lot because there's a lot of good information on it today. We have a document explaining how to develop an anti-retaliation program. And that's important because having an anti-retaliation program helps ensure that your employees feel free to speak up and explain when there are safety and health conditions and situations that need to be discussed. And so making sure that people can speak up is a great way to promote safety. So next slide, please. So generally, who is covered by the statutes that we administer? So generally, most of our statutes protect private sector workers against retaliation by their employers. But I'd like to point out that the National Transportation NTSA, the National Transportation Safety and Security Act, covers state and local employees who work for a public transportation agency. And this includes managers. So anyone who is employed by these agencies is covered. It doesn't matter if they're rank and file or if they're a manager, which is another question we received before the event. Another question that was brought up is whether there are protections if you are in a state plan state where local workers are not, where you're in a state where there's no local OSHA state OSHA that protects public sector workers. And the answer is yes. So under the statutes we're going to talk today, the NTSSA, the Federal Railroad Safety Act, and the Federal Motor Carrier Safety Act, you are covered by those statutes, even if you are in a state where, if you're depending on what your role is, you will be covered under those statutes no matter what state that you live in, even if you are not covered by a state equivalent of the Occupational Safety. Next slide, please. So what do we do to protect whistleblowers? What is OSHA's role here? We investigate complaints, and as I said earlier, my colleague is going to explain later how OSHA does this. We conduct outreach for employers and employees like we are doing with now, and we work with our partner agencies, most importantly for the purposes today, the FTA, the Federal Railroad Administration, and the Federal Motor Carrier Safety Administration. Next slide, please. So the office where I work and where Jared is currently on detail is the Directorate of Whistleblower Protection Programs, or DWPP for short. And so we handle all of sort of the national policy issues. All of our investigations are done in the region by our regional folks, and OSHA has 10 regions. But what we do is we administer what we call our request for review program, which is an appeal process under a few of our statutes, including the Occupational Safety and Health Act. We develop policy documents such as the Whistleblower Investigations Manual, and that explains how we conduct our investigations. A copy of that is also available on our website. Again, that's whistleblowers with an s.gov, another federal agency whistleblower.gov before we got to it. We conduct rulemaking under our statutes. As I said earlier, we coordinate with partner agencies. We have an outreach strategy. We respond to Freedom of Information Act requests in various public inquiries. We handle the data for the program. We review significant cases by the regions, and we have a process for that. And we also develop and deliver training to our field staff. Next slide, please. And so, as I said, the real meat of what our program does, all of the investigating, happens at the region. It happens in the 10 regional offices that we have. And we have a map on our website explaining which states are in which regions. And one thing to note is about half the states are part of the federal OSHA, and about half the states have their own version of OSHA. And so for complaints filed under the Occupational Safety and Health Act, if you're in one of those state plan states, those complaints are going to be handled by the state rather than federal OSHA. But if you have complaints under any of the other statutes, no matter what state you live in, federal OSHA is going to be investigating those. Next slide, please. So if an employee believes that they have been retaliated against, and we'll talk a little bit more about retaliation later, they can file complaints with us in many different ways. And if you are, most people file their complaints online. We have an online complaint form at whistleblowers.gov. You can also file by any of the other means on this slide. The language that you file in doesn't matter. They don't need to be in any particular format. They just need to be in by the deadline. And we'll talk about deadlines a little bit later. And complaints that are filed online, if they belong in the state plan state, they will be shared with the appropriate state plan. If you call federal OSHA, we will make any referrals that are appropriate. But state plans may also have their own methods for filing. On our website, we also list some helpful information to have when you file a complaint, and Jared's going to talk a little bit about what those materials are later. Complainants also have the right to duly file with federal OSHA and the respective OSHA approved state plan for private sector cases only under the Occupational Safety and Health Act, because federal OSHA's Occupational Safety and Health Act doesn't cover public sector employees, but they may be covered by the states. And timeframes may be as short as 30 days, depending from the time of the adverse action against the employee. So we always recommend that employees file as early as possible in one of these ways. Next slide, please. So we're going to start talking now about the actual statutes that cover employees. So NTSSA, the National Transportation Safety and Security Act, it's easier to say NTSSA, so we're going to shorten it, protects transit workers because it prohibits a public transportation agency, contractor or subcontractor of that agency, or an officer or an employee of the agency from retaliating against an employee for having engaged in protected activity. Next slide, please. So what employees are covered under the statute? Who's covered? So employees of a public transportation agency or its contractors or its subcontractors are covered under these agencies. But there's an explicit carve out for employees of providers of other passenger transportation, including school buses, charter buses, or sightseeing transportation. So those employees, depending on what they're alleging, may be covered under Section 11C of the Occupational Safety and Health Act. They may be covered under an equivalent state law. They may also be covered under the Surface Transportation Assistance Act, and that act covers commercial motor vehicle carriers. So drivers of intercity transportation may be covered under that statute if certain conditions are met. And we have additional information on our website. We've got fact sheets and desk days and other information about the Surface Transportation Assistance Act, which we call STA for short, on our website. So anyone who thinks that they may not be covered under NTSSA or FRSA, which I'm going to talk about later, you may want to take a look at the materials we have on that. Next slide. So the next statute, the Federal Railroad Safety Act, prohibits railroad carriers, including publicly funded commuter railroads, a contractor, subcontractor of such railroad, or an officer and employee of such railroad from retaliating against an employee for having engaged in protected activity. Next slide, please. So who's covered under this statute? So employees of railroad carriers, including publicly funded commuter railroads, are covered. And so sometimes questions arise about whether an employer is a commuter railroad covered by FRSA, or if they are urban rapid transit, which is excluded from FRSA's definition of a railroad. And so OSHA generally consults Federal Railroad Administration guidance to determine whether the employer is a covered commuter railroad or not. And commuter railroad employees may have whistleblower protection under both FRSA and NTSSA. So notably, FRSA does not cover urban rapid transit operations such as street railways, trolleys, subways, and elevated railways that are not connected to the general railroad system of transportation. Generally, urban rapid transit is not likely to be covered if it's a subway or elevated operation, but it's in a track system on which no other railroad may operate, has no highway rail crossing to grade, operates within an urban area, including the suburbs, moves passengers from station to station within the urban area as one of its major functions, and provides frequent service even outside morning and afternoon peak periods. So examples of urban rapid transit include Metro Rail in DC, which I took this morning to get to work and which I have to get home, Chicago Transit Authority, the L, and subway systems in New York, Boston, and Philadelphia. But these urban rapid transit system employees are protected by the NTSSA. whistleblower protection. Next slide, please. So what's protected? So generally the way our statutes work is an employee engages in protected activity, their employer retaliates against them for engaging in that protected activity. And so that's the kind of conduct that we cover. So what are these protected activities? Providing information in various investigations, and these investigations have to violate to violations of federal laws and regulations relating to railroad or public transportation safety or security. And generally, the Employees Act, how we assess protected activity is the Employees Act must be lawful and done in good faith, which is generally presumed. The protection for providing information, directly causing information to be provided, or otherwise directly assisting in any investigation regarding any conduct that the employee reasonably believes violates any federal law, railroad, or regulation relating to an FRSA, railroad safety or security, gross fraud, waste, or abuse. And under NTSSA, if it relates to public transportation safety or security or fraud, waste, or abuse, or a federal grants or other public money, or if you provide any information or assistance to federal, state, or regulatory law enforcement agencies about these issues, a member of Congress, government accountability office, or a supervisor or person who has the authority to investigate, discover, or address the misconduct that you're reporting. Next slide, please. Additional activities include refusing to violate or assist in a violation of any federal law, rule, or regulation relating to public transportation or railroad safety or security, filing a complaint or causing a proceeding to be brought, or testifying in a proceeding under one of these laws, rules, or regulations, or reporting a hazardous safety or security condition. Next slide, please. Finally, the other, under both NTSSA and FRSA, there are some protections for refusing to work. So an employee is protected for refusing to work when confronted by a hazardous safety or security condition if the refusal is made in good faith and no reasonable alternative to the refusal is available to the employee. A reasonable individual in the employee's circumstances would conclude that the hazardous condition presents an imminent danger of death or serious injury, and the urgency of the situation does not allow sufficient time to eliminate the danger, and the employee, where possible, has notified the employer of the existence of a hazardous condition and the intention not to perform further work. However, importantly, security personnel, including transit police, employed or utilized by a public transportation agency to protect riders, equipment, assets, or facilities, are not protected for refusing to work. In addition, an employee is protected for refusing to authorize the use of any safety or security related equipment, track, or structures if the employee is responsible for the inspection or repair of the equipment, track, or statutes, the refusal is made in good faith, and no reasonable alternative to the refusal is available to the employee. A reasonable individual in the employee's circumstances would conclude that the hazardous condition presents an imminent danger of death or serious injury, and the urgency of the situation does not allow sufficient time to eliminate the danger, and the employee, where possible, has notified the employer of the existence of a hazardous condition and intent not to authorize the use of equipment, track, or structures. And we have information on activities that about refusal to perform certain tasks, just like I've talked about on our website. So I know that this is a lot of information. So I also recommend going to, if you have any questions about this refusal to work, go to our website and take a look at that page. Next slide, please. So there are some activities that are specifically protected under FRSA that are not specifically protected under NTSSA. So, and these are relating to reporting of injuries and other things. So we're protected from notifying or attempting to notify the railroad carrier or the Secretary of Transportation of a work-related personal injury or illness of an employee. We're protected for accurately reporting hours on duty and requesting medical or first aid treatment. Railroad carriers, notably, are also prohibited from delaying, denying, or interfering with medical or first aid treatment for a work-related injury, and they must transport an employee injured in the course of employment to the nearest hospital where the employee can receive treatment upon request. Notably, both the FRSA statute and the NTSSA statute are what we call contributing factor statutes. This means that if the employee's protected activity is a contributing factor in their employer's decision to take an adverse action against them, the employee may have a merit case. Next slide, please. So, like I said, I was going to talk about our website a lot. So we have a lot of resources available on our website. Again, it's on the slide, whistleblowers.gov. We have the text of the regulations, we have the text of the statutes, we have fact sheets, we have desk aids, which are a deeper dive into how our investigators should investigate these statutes. And so all of these materials are good sources of additional information if you have questions about how these particular statutes work. Next slide, please. So just sort of generally, under these two statutes, complainants have 180 days to file a complaint with OSHA. Different statutes have different timeframes. Most notably, the shortest one is under Section 11C of the Occupational Safety and Health Act, which is 30 days. Under the statute, we have 60 days to investigate, but that's more of advisory than anything else. Investigations typically take far longer than that. And my colleague is going to talk about generally what to expect with the length of an investigation a little bit later. But after the agency makes its findings, either party has 30 days to request a hearing with the administrative law judge. After an administrative law judge hearing, you have 14 days to request a review from the administrative review board. The administrative review board has 120 days to issue a final order. And after that, you have 60 days to file a petition for review in Court of Appeals. And so really all of this is here to illustrate that a complaint can take unfortunately can take a very long time from the filing of the complaint to the resolution of the complaint, depending on how many times it has been appealed and how long the investigation process takes. So these things can unfortunately take a lot of time depending on how complicated they are. Next slide, please. So some of the available remedies, if the agency does find merit, are the employer must take affirmative action to abate any violation. In some cases, there's preliminary reinstatement, back pay with interest, compensatory damages, including attorney's fees, and per the statute, punitive damages are available, but the cap on it is $250,000. Next slide, please. And finally, there is something we also have to talk about under these particular statutes called election remedies. And so complainants may have to choose among the Federal Railroad Safety Act, the National Transportation Safety and Security Act, Section 11C of the OSHA Act, or a state whistleblower statute. And complainants don't have to choose. You don't have to choose right away if you're filing a complaint. It's one of those things that just has to be figured out as the complaint goes on. Notably, complainants do not have to choose between pursuing a remedy under one of OSHA statutes or pursuing a remedy under a collective bargaining agreement. And you also don't have to make a choice if you are pursuing anti-SSA or FRISA claim in something else like a claim before the Equal Employment Opportunity Commission. So as an example, let's say we have an employee of a subway system who files a safety complaint with OSHA regarding a hazardous workplace. They've engaged in protected activity under both Section 11C of the Occupational Safety and Health Act and under NTSSA, they have to choose either one. Next slide, please. And with that, I'm going to turn this over to my very able colleague, Mr. Jared Klein, to talk about what to expect in an OSHA retaliation investigation. Jared?
Hi, thank you everybody for having me. Again, my name is Jared Klein. I am a regional whistleblower retaliation investigator covering effectively the entire Western United States. I've been with the government for roughly 30 years and been with OSHA since approximately 2016. As you guys may be feeling, the filing of a retaliation complaint and the procedures can be very overwhelming. It can be very confusing. Here at OSHA, we understand that, and the investigators absolutely understand this. We deal with this on a day-to-day basis. We're here to help you get through the process, not just the complainants, but also the employers and the management. Not to mention union officials, safety officers, anybody that may be involved in a retaliation complaint. I'm going to be reiterating and repeating a lot of the items that we just heard from my colleague. Our hope is that this is going to alleviate some of the overwhelming feelings that you have. Our goal is to get the information out there so that you understand what we are doing, and you can even pass on some of the information to your colleagues and your family members who are also out in the workforce. Next slide, please. So, as it's already been mentioned, a complaint can be filed in any language. OSHA is going to have it translated, and if it's not in English, and we will communicate in the appropriate language. If we have to use an interpretive service, the government has access to interpretive services. Usually it's by telephone, sometimes it may be a video system. As previously mentioned, we will take a complaint in any format. However, if you have access to a computer, considering the modern technology, our preferred method is to file online, but we will still take it by mail, by telephone, in person. A lot of times transit workers might be out in the field and can't get to a computer, and their only way to do it is by phone, and that is fine, and we will handle it. I do ask, though, if you do file online, please be sure that you receive a confirmation that your complaint has been submitted. Occasionally, things have fallen through the cracks. In very short amount of time, an investigator will reach out to you as soon as possible. Please ensure that any questions in the complaint forms that you have filled out are answered to the best of your ability and completely. It will help the investigators in evaluating your complaint. It's been mentioned a couple times. Our website is whistleblowers. There is an S at the end of whistleblowers. It's very important. Also, it's .gov, not .com. If you don't put the S on there, if you don't put .gov, I don't even know where you're going to end up. In an OSHA whistleblower investigation, the employee who files a complaint is referred to as the complainant. And the employer and the management against whom the complaint is filed is going to be referred to as the respondent. Neither side, neither the complainants nor the employer, the respondent, is required to retain an attorney. But if a party designates a representative, such as an attorney or a union representative even, the designated representative is going to serve as the point of contact between OSHA and the party. You will likely have many questions for the OSHA investigators. Unfortunately, we can't answer any legal questions, but we are going to be extremely happy to answer any procedural questions that you have. Any legal questions that you have must go to your own legal counsel if you have one. As a side note on that, most of the questions that you have are probably going to be on our website at whistleblowers.gov. Next slide, please. It is very important that all parties fully cooperate in the investigation. If a complainant fails to cooperate, the complaint may be dismissed. If the respondent fails to cooperate, a negative inference may be taken, which could lead to a finding of merit in the complaint and investigation. During the investigation, if you move, if you change your phone numbers during the investigation, it is extremely important that you notify your investigator immediately of the new contact information. If we can't contact you, your complaint may be dismissed. Also, at the same time, please make sure your voicemail is working and you monitor your email so that you can respond to requests from the investigator. Next slide, please. Across the country, the different OSHA regions might start their investigations in a different manner, and that's fine. That's decisions that the regions do make. This is the intake and screening phase of the investigation. This includes your initial complaint, which may have been the online complaint that you filed, or the phone call, or the letter that you sent to OSHA. OSHA is going to interview the complainant to obtain information about the alleged retaliation and will determine whether the allegations are sufficient to initiate a full investigation under one or more of the 25 whistleblower protection statutes administered by OSHA. As previously mentioned, cases filed by transit workers may fall under the NTSSA, the FRSA, There might be some allegations that fall under Section 11C of the Occupational Safety Act. It's possible that some of your allegations might even fall under the Surface Transportation Assistance Act, which covers certain set of commercial motor vehicles, such as city buses and other bus drivers. Those are some possibilities. The key here, though, and that's confusing. We're talking about 25 different statutes. You don't need to worry about any of that. OSHA's investigators know the statutes. You don't need to learn about the various statutes. The investigator will examine all of your allegations through an interview. It could be a half-hour interview, maybe an hour, maybe even longer interview, in order for us to determine the appropriate statute or multiple statutes for filing. Regardless of which statute the complaint is filed under, how the investigation is conducted is generally going to be the same. Next slide, please. If the allegation of retaliation is sufficient to proceed with an investigation, the complaint will be signed to an OSHA whistleblower investigator. The OSHA investigator does not represent either party, but is a neutral fact finder. In other words, OSHA does not represent the complainant. OSHA does not represent the employer. We seek to determine if the retaliation provisions of the statutes have been violated. The investigator will notify the complainant, the respondent, and the appropriate federal partner agencies such as the FTA, the FRA, or the DOT that OSHA has opened up an investigation. Next slide, please. The complainant and the respondent, the employer, should keep any potential evidence regarding the circumstances of the allegations, including all pertinent emails, letters, notes, text messages, voicemails, phone logs, personal files, contracts, work products, meeting minutes. Additional information about useful documents to have before filing can be found again on our website. Oftentimes, a complainant might not have access to many of these documents after suffering an adverse action. The OSHA investigators are very familiar with this issue. It is very important that if you think that you may be subject to retaliation, you collect as much documentation as possible to prove your case. Generally speaking, OSHA does not have subpoena authority to obtain documents that are not voluntarily provided to us. Farther on in the court system, those issues can be resolved. OSHA is going to request that both parties also provide each other with a copy of all submissions that they have made to OSHA related to the complaint. Our investigations are an open-ended investigation. We want the complainant's documents to be provided to the employer and the employer's documents to be provided to the complainant. Also, the parties should ensure that they provide any contact information for any witnesses who could support or refute the alleged retaliation. Also, union officials oftentimes are contacted to assist in the investigation. Next slide, please. OSHA is going to ask the respondent, the employer, to provide a written defense to the allegations. Also, this is known as a position statement. As previously mentioned, both parties are expected to actively participate and cooperate in the investigation and to respond to OSHA's request. Both parties are given an opportunity to rebut the opposing party's position. Next slide, please. You already saw briefly the official timeline of an investigation. Generally speaking, OSHA has a significant caseload that does cause delays in coming to a final determination by OSHA and its investigation. A complainant should not expect a full investigation to be completed and a final OSHA resolution in weeks or even a month or two. The reality is it may exceed 1 year for a full investigation to be completed. Then there is also the potential for an appeals process. OSHA is always striving to reduce its timeline every day. You should have from OSHA your first contact when you file a complaint, generally within 1 to 2 weeks. Your first interview is generally going to occur within 2 to 3 weeks, but it might actually be part of that first contact with the investigator. A position statement from the employer is due in 20 days after receiving notice from OSHA about the complaint. But usually it's going to be submitted about 30 to 45 days if OSHA grants an extension to the employer. Your opportunity to provide a rebuttal, both in writing and a follow-up interview, is generally scheduled within about 4 to 6 weeks from the receipt of the position statement. This is your chance as a complainant to argue against the position statement from the employer and the evidence that was submitted by the employer. That is also your opportunity to provide additional witnesses and additional evidence. Next slide, please. It was already briefly discussed about the case dispositions. At the end of the investigation, there will be a disposition of the case, either a finding of merit or a dismissal. There are other ways the case may be disposed of. The parties may choose to settle the retaliation complaint at any point in the investigation, either through the assistance of the assigned investigator or through their own negotiated settlement that OSHA approves. Alternative dispute resolution, we call it ADR, is a form of mediation. We offer both a formal and an informal ADR. The formal version is through a trained and certified mediator. There will be full confidentiality during the formal mediation process, and the assigned investigator is not going to learn about anything that is discussed through the formal ADR process. The informal ADR process is where the assigned investigator works as a go-between for the parties until there is an agreement. The ADR mediator and informal investigator go-between do not have any arbitration powers. It is up to the parties to decide if they want to come to an agreement or not. The next option is what we call the Expedited Case Processing Program, ECP. Both parties have the ability to appeal OSHA's determination at the end of the investigation. This appeal goes to the United States Department of Labor Office of Administrative Law Judge, the OALJ, for what's called a de novo review. That means it's from the beginning. The judge is not going to see any of the evidence collected by OSHA. The parties must bring all of their evidence that they had brought to OSHA to the judge for review. Only the complainant may request that OSHA dismiss the complaint so that the case can be brought to the ALJ prior to completion of the investigation. Another option that might be available is what's called a kick-out. Again, only the complainant may request to bring a complaint to the United States District Court on what we call the kick-out. Unlike the ALJ, there are filing fees and other obligations at U.S. District Court. It is available under some of the statutes, including the FRSA and the NTSSA, but it's not available immediately. You would have to wait under those statutes for 210 days to pass before you can enact your kick-out options. The Occupational Safety and Health Act, Section 11C, does not have a kick-out option. At any point in time, a complainant can choose to withdraw their complaint if they deem it appropriate to do so. The investigator is going to ensure that the withdrawal is knowing and voluntary and that there has not been any undue influence from the employer. In rare circumstances, OSHA may defer to other proceedings, such as a proceeding under a collective bargaining agreement or a state court. More information on this can be found on in our Whistleblowers Investigations Manual, which can be found on our website. Next slide, please. If the complaint has not already been settled or another path has already been taken, allowing for the investigation to come to a final conclusion of the investigation, The investigator is going to make a recommendation to his or her supervisor regarding whether the evidence provides reasonable cause to believe that the respondent violated the specific statute or statutes in question. If the supervisor and management concur with the recommendation of merit or a recommendation to dismiss the complaint, OSHA is going to issue a findings letter. We call it the secretary's findings. The letter will be issued to both parties, and it's going to include information about remedies, if a finding of merit, and the right to object and appeal the decision and have the case heard by an administrative law judge, if the parties deem appropriate, except in cases under Section 11C of the Occupational Safety and Health Act. Next slide, please. For cases filed under the administrative statutes, such as the NTSSA, FERSA, and the STA, any party may object to the OSHA determination and request a hearing before the ALJ, as I had already mentioned. A petition for a review of an ALJ decision by the ARB, the Administrative Review Board, and can petition the Secretary of Labor for review of an ARB decision. Further petitions for review, and that's an appeal, can also be filed with the U.S. Court of Appeals. A handful of cases have been appealed to the United States Supreme Court, but that's rare. Section 11C of the OSHA Act is different. Under Section 11C, the complainant may file a request for review with the OSHA Directorate of Whistleblower Protection Program, DWPP. That is the program that my colleague and I are working with right now. If it's dismissed, this will be the final review. If the investigation is deemed to merit, the case will be litigated at the U.S. District Court. It is possible that the remedies may be different, and the investigator will discuss this with you if appropriate. Next slide, please. I think that is going to bring us to the end of our presentation, and I do believe we are going to open up for some potential questions at this point.
Yes, and we got one question about whether there were any sort of fact sheets available about union representation, and we don't have any written materials about that, but employees are allowed to be represented by someone of their choosing. It can be an attorney. It can be, we've had people represented by their spouses. We have had, unions represent employees. When you file a complaint online, there is a place to put information about someone who is representing you, and you can click a button, allowing that to happen. When, as you know, when we send out information, docketing the case and saying that we include a form allowing you to fill out if anybody is going to represent you. So that information is available sort of once you file, but we don't have any outreach materials on that particular issue.
And generally speaking, when you do designate a representation, if you as a complainant or the employer have information to go to OSHA, that information should be funneled through your representative. And when OSHA has to converse with the employer or the employee, we will funnel it through that representative as well.
Good point. The next question is, some transit agencies support FRA commuter rail and FTA rail public transit. Do they need to be specifically categorized as a commuter rail employer to fall under FRSA? So I believe the answer to that is yes. So, when the complaint comes in, as Jared said, we take a look at it, and we take a look at who the employer is and what they cover. And then OSHA makes the assessment as to whether the entity is more properly considered a railroad, or if they are more properly considered urban rapid transit. And so that is going to then, depending on the actual facts of the case, everything is fact dependent. So depending on what we find out about the particular employer, we will then figure out what the appropriate statute to proceed under is.
And once again, that is our obligation as the investigator. The person that filing a complaint does not need to worry about that. We have a lot of resources to determine the appropriate statute or multiple statutes that it may be filed under.
And when we have concerns, we also work hand in glove with our solicitor. So this is not just So it's not just necessarily one person making this decision, you know, so we always try to ensure that if the complaints are filed under the appropriate statute, and sometimes if there may be more than one statute in play that is appropriate. So as Jared has said multiple times, and it is worth it, I think this is an important point worth repeating. We will figure that out. You just have to tell us the activity you engaged in and what your employer did and what they knew, and then we will go from there. Yes, and so what we are talking about are the next question is this just for retaliation complaints? And yes, we are just talking about retaliation complaints. And as I said earlier, if we're talking about safety complaints that are not happening sort of while you are actively, you know, sort of working in transit. So safety complaints involving the building where you work or some other thing about the facilities where you work, you know, sort of anything like that. That could be a safety and health complaint under OSHA. If there are other safety complaints about your working conditions, you can bring those to the appropriate agency handling sort of the underlying complaints. But what we are talking about today and what our program specifically handles are the retaliation complaints. So our contact information, generally everything, everything goes through our website, whistleblowers.gov. If you have specific questions, you can address them to our regions, and we have information on our website for questions are generally better handled from the regions that you are in. So I recommend going to OSHA's website, finding out you know, the most appropriate place, and then calling your closest area or regional office. So that's generally
Preferably the regional office, because the retaliation investigators are assigned to the regional offices. The compliance officers are going to be assigned to the area offices. As mentioned earlier, if there is a compliance complaint, that's going to have to, the compliance complaints go to the appropriate agencies such as the DOT, the FRA, or if it's a health and safety and occupational safety and health act, that goes to our compliance section, not our retaliation section of OSHA.
Right. And we have another question about whether light rail is covered, and light rail is likely to be considered urban rapid transit and will be covered under the and will likely be covered. I always have to not be categorical, but may be covered under the NTSSA. All right, so I think we've answered all the questions I can see. Oh, no, there is no certificate of, alas, there's no certificate of completion or continuing education credits for this class. I wish there were, but alas, no.
Thank you, Megan. Thank you, Jared. This is Bridget Sambarini from the Federal Transit Administration. I just want to remind you, if you do have a question, there is a Q&A tab on the bottom of your screen, so feel free to write your question in that box there. We can wait another minute or two for some additional questions. Right now, I'm not showing any additional questions. Oh, one just popped up here.
How should a state government handle complaints that come in from an agency from a non-state plan state? If we're talking about a retaliation complaint, people should be referred to, I always hope, you know, as Jared mentioned, the best place to file a complaint is generally online with us. So I'm not, kind of interesting questions, not one I've really thought about. I think that answers the question.
So some states might have their own statutes that cover the issue, but at the same time, the state government should be referring the person filing the complaint over to OSHA. At our whistleblowers.gov is the preferred manner. You know, but if the person needs to send it by mail, fax it, telephone, whatever, you know, if the state government receives it by mail, they can forward it to us directly.
I am not showing any additional questions. Remember to post any questions in the Q&A link at the bottom of your screen.
No, you do. So there's a question, must you have a representative? Absolutely not. And the vast majority of people who file complaints with us are not represented. So, no, you must not, that is not a requirement. Is there a full series associated to this subject? No.
I don't understand what series means.
I think maybe under more of our statutes. We're always looking at additional outreach opportunities. But no, this is I think that this is a one-off presentation. This is not like the first of the series. So I think that's the answer to your question. Does OSHA notify a union representative along with employer when a complaint is filed, regardless of complaint seeking representation? No. So when we docket a complaint for investigation, the employee gets notified that it's been docketed. The employer gets notified that it's been docketed. And if the employee has affirmatively told us that they have a representative, they will learn about it, but we do not proactively provide information to a union representative. The statutes we enforce are the Privacy Act applies to them, and so that limits to some extent the information we can share with people, because the employee and the employer are both part of the complaint. We share that information with them, but we do not proactively share information with a union representative unless an employee has officially told us they want us to.
And part of that has to do with our confidentiality. When we do ask about witnesses, we provide confidentiality to witnesses in accordance with the law. Again, there are Privacy Act issues. If the complaint were to go to court, the witness's identity may have to be divulged, but during the investigation, we are going to keep the witness's identity confidential to the best of our ability.
Well, that's for, I mean, right, for fellow employee, not necessarily for managers, but definitely for rank and file employees. We have one more question, which is, are there any consequences for filing multiple complaints that are proven to be invalid? And the answer to that is no. Every complaint that comes to us, we handle as if it's a new complaint, and even if someone has filed multiple other complaints previously. So no, there are no consequences for that.
I'm looking at the clock here. We are almost at time here at 1:58, and I don't see any additional questions at this time. So I think we're going to begin to wrap things up. So on behalf of Joe DiLorenzo and the Federal Transit Administration, Megan and Jared, thank you so much for your time. And I want to thank everyone for attending today's webinar. I'd just like to remind you as well that this recording will be posted on FTA's website soon, as will the slides that were presented today. But before you leave, I see Ariel just posted a link to the chat box. That is a survey. We are asking if you could take the time to fill out the post-webinar survey in the chat that provides feedback to us on how we can continue to make these forums valuable to all of you. So I think the chat is there, the survey is there. The link is posted in the chat box. So please, I urge you to if you have the time to complete that survey. And with that, I want to thank you for spending your time with us this afternoon or this morning if you're calling from the West Coast. And I want to wish you a very wonderful day. Thank you so much. And that concludes our webinar today.